Welcome back to the Law and Crime Network. This is Bob Bianchi. While the jury is reviewing this document that a previous Judge Stevens had written with respect to the sentencing recommendation to the judge that would actually be doing the sentencing because he was retiring, I'm going to bring in our guest, Andell Brown. He is a defense attorney out of Miami, Florida. And what I really love about Andell is not only is he in private practice, but he was a public defender doing God's work, as we like to say, right, Andell? Welcome to the show.
Thanks, Bob. I like to think the same.
Yep. You guys have a tough job as public defenders, and I respect that very much, even as a prosecutor myself. We're going to go. I'm trying to determine whether or not the jury is reviewing this document. I guess our producers will let us know when something's actually happening in court. So, Andell, I'm trying to break this down to the folks out here. And what essentially Wallace Bradsher is trying to do, the former district attorney that is now turned defendant, is basically say the credibility of Bradsher is affected by the fact that he not only pled guilty, but he was getting this prayer for judgment. States call it different things, but essentially it's even less than what the plea agreement was, where they probably will even enter into a conviction for him, and that goes to his credibility, that he'll say anything, he'll lie about anything, because essentially he'll have no real penal consequences or criminal consequences down the road. Is that how you're seeing all this, Andell?
Well, I think that's what you got to do as a defendant or a defense attorney, is show that this witness has an interest. They have a bias. They have a reason they're up here saying what they're saying. And I think in this case, what Bradsher is bringing to the forefront is Blitzer is trying to save his own skin. That's why he's saying these things. He's saying these things because if he really gives the prosecution what they want, he's going to get out of trouble. And who doesn't want to get out of trouble?
Right, and he tried to do that on cross-examination with respect to the quote-unquote sweetheart deal he got, but this goes one step further to say that prior to that plea being entered, Andell, let's talk to our viewers about this real, true, realistic practice point here that happens all the time. Bradsher's indicating that they went into chambers with the judge beforehand. In Jersey, we call it the third page agreement, or I'm sure they call it all sorts of different things in other states. In other words, there was a wink and a nod in chambers that if he pleads guilty, it'll even be less than what's on paper. So the public sees, okay, we took this seriously, but in reality, there's something even better. It's kind of an insidious process. Have you encountered that, Andell?
I've seen it in so many different ways, and I'm sure, as you know, Bob, there's so many different ways for cases to get negotiated, and there's certain things that may show up on the record and other things that don't. And I think in this case, that's exactly what he's saying. He's saying that there was another agreement other than the official agreement, and that's why Blitzer is here testifying, because he wants to get the benefit of that wink-wink deal.
Yeah, absolutely. I'll tell you, when I became, and this case has a fascination for me, Andell, because I was appointed by the governor. We were appointed in New Jersey as the chief prosecutor, just like these two guys. Even though they were elected, they were the head of their offices. And I knew that third page agreement, or that wink and nod stuff, was happening inside of the judge's chambers. I experienced it as a criminal defense attorney before I was prosecutor. I experienced it as an assistant prosecutor. And I put a zero tolerance rule on that with my staff, that there will be no sidebar agreements that are not publicly documented and on the record, so that the victims and community know exactly what the parameters of the plea agreement are, and that winks and nods by definition, Andell, are deceptive. And I think that's what Bradsher is trying to expose here.
Absolutely. I think what he's trying to show is that this is a system where a lot of things are going on that don't necessarily show up on the record, and there are motivations that are going on behind the scenes. And Bradsher is saying, I'm a victim of all of that. I tried to do the right thing. I asked for advice. Yeah, I might have made some mistakes, but I'm not a criminal.
Yeah, I mean, it's fascinating. Bradsher also made the representation to the judge, and he's representing himself. There's that axiom. Let's be a little cliche, and he who represents himself has a fool for a client. Our viewers have heard it. You have heard it.
And for a lawyer.
Exactly. Excuse me. But he's indicating he has got evidence and information that these sidebar deals were made behind the scenes prior, and that, I think, compelled the judge, which it appeared at one point the judge was not going to admit it, because he said the prejudicial value outweighed the probative value of the evidence. But then I think that argument persuaded him to at least cut the baby in half and let some of it be introduced for purposes of affecting Craig Blitzer's testimony on the witness stand, his credibility, but not all of it. So it'll be interesting to see if Bradsher, who does not, as a defense, even though he's a defense lawyer, even though he's a defendant, he does not have to let the court know exactly what that evidence is right now. It'll be interesting to see whether or not he actually has something. What are your thoughts?
Yeah, I mean, I really want to see what he's going to come up with, Bob. And, you know, to be honest, that old axiom, we all say it, we all think it, but watching Bradsher, some of his testimony, his opening statement, he seems to be doing a pretty good job.
Yeah, hey, listen, he is a good lawyer. I mean, he was making some pretty compelling arguments. He's not afraid. He's natural in the courtroom. He makes good legal arguments. But it's just a shame to see people who are, you know, district attorneys aspired to such an honorable position. And when I was in that position, one of the things is, in my mind, and I think you would agree with this, Andell, your prosecutors have to be as impeccable as human nature will allow. And it starts from the top down. And I'm talking about the fact that we wouldn't even let people, myself included, even get a free cup of coffee. Taxpayer money was considered more sacrosanct, more protected than my own personal money. It's making sure, even if you could do it, doesn't mean you should do it. So to see a scheme like this, I mean, it's just swampy, to use that term since that's popular in today's nomenclature. It's in my mind, stretching every ethical boundary, and now may actually be criminal. And it's really disgusting to see, because I think the citizens of North Carolina deserve better than this.
Bob, I think we want from our law enforcement officers, our prosecutors, our people in government to shun even the appearance of impropriety. If something might be wrong, if it looks like it may be wrong, it's best just to stay away from it. So we totally agree with that sentiment. I think the defendant here he's trying to explain, and you know, he's gone through a timeline that brought from him coming from private practice, what seemed to be a successful practice, going into public service, bringing his team with him, what seemed to be for a noble purpose. And somewhere along the line, he says he made mistakes. I think it's absolutely tough to see people we hold in such high esteem in these positions. But I think the defense they have something to fight with. He has some ammunition to defend himself, and I'm really interested to see what else comes out in testimony and what ultimately happens in this case.
I agree completely. And, you know, Andell Brown here from defense attorney, was formerly a public defender, is now in private practice. And listen, I was in private practice before I became prosecutor, and there's no doubt about it. You take a substantial, many people take a substantial pay cut for the honor of serving in that position. But the way to do that is not to try to get that money through nefarious means with the taxpayer. It's good financial planning, and if you can't do that, then don't take the job. We are at the Law&Crime Network. I want to welcome our viewers. What's happening in court right now is really nothing. The jury is looking at this letter from Judge Stevens that this particular judge right now that you see in court on your screen has redacted certain information. He's allowed Bradsher to use that to try to affect the credibility of the former district attorney that is now state's witness, Craig Blitzer, in order to say, hey, you didn't just get the deal that's on paper, which was a sweetheart deal to begin with, but you actually got something in chambers and a wink and a nod that's even better than that, which will actually lead to you not even having any responsibility for the crimes you committed. So, folks, please know that once the testimony starts again, because we are the gavel-to-gavel coverage network, we are going to have my producers going to ring in my ear, say, Bob, cut it out, shut up, and go right back to the courtroom. But right now, there's nothing happening. Andell, I love having you on the show. And as a defense lawyer now, I put your defense lawyer hat on. We talked about, you know, what we expect from our public officials and our prosecutors. But as a defense lawyer, you had mentioned that you think that there's some arguments here. I want to go to the obtaining of the property under false pretenses. I don't think that this is necessarily a slam dunk charge in this case. What do you think?
Not at all. I think the defendant here, he operated with a lot of transparency. There are memos where he's saying, hey, this is what I'm doing. Is this okay? He's reaching out to the administrative office of courts. He's reaching out to the chief judge, so many other individuals that are part of the process, and saying what's being done. It doesn't seem like he was hiding anything. So I just don't see where the intent to deceive or defraud is going to be there for the prosecution.
Yeah, there's a lot of wiggle room in that. I'm just going to see from our producers right now whether anything's happening. We're going to go to court. The judge is speaking, and we see you on the other end, Andell.
All right.
Welcome back to the Law&Crime Network. I actually respect that lady. I have a hard time sleeping in a bed, and she can do it on the road. So, God bless her. Thank God she wasn't injured. You're at the Law&Crime Network. This is the only gavel-to-gavel coverage network where you're going to be able to dedicate it to trials all the time. We love our viewers, and the questions that they're asking are always very insightful. I've got Andell Brown with me. He's a great guest, former public defender, doing God's work out there as the public defender, and now in private practice doing criminal defense. Andell, welcome. We are dealing with the North Carolina versus Wallace Bradsher case. Gosh, Andell, I mean, this is like still a reoccurring nightmare for me, being the head district attorney or county prosecutor and then being called defendant. And, you're in the business of judging people's conduct. I always used to say to my staff, we don't judge people. That's for a higher authority than us. We judge conduct. And you should always balance that conduct as a prosecutor with mercy and compassion where appropriate. And then where you need to protect the community, you've got to go hard. It's a really tough job. It's very nuanced, making these really dramatic judgment calls. We're seeing pictures right now in the courtroom. These aren't bad people. There they are. These are the wives and their homes, and there's the defendant on trial right now. We see a picture of him, Wallace Bradsher, and I mean, now he's a defendant, and he's actually representing himself. It is such a tragic downfall. And, my dad, I always refer to him, 86, he always, used to tell me things like, a moment of ecstasy, a lifetime of pain. We see that in our practice all the time in many ways. But especially when you're in a position of authority and given the responsibility, the huge responsibility of being a prosecutor to protect the community, you need to have great humility and great restraint with that power. And it seems to me these two guys kind of went in the opposite direction. I get it. It's a lot of power, a lot of discretion given to them. But they, instead of using that humility and restraint, went in an obnoxious way, whether guilty or not guilty, went in an obnoxious way to defraud, if you will, the taxpayers by hiring and swapping their wives for either no-show jobs or almost no-show jobs. Pretty disheartening, don't you think?
Yeah, I mean, it's always tough when you have people that were in such positions of trust that are now on the other side. But it also kind of shows what I think we try to get jurors and other people to understand as defense lawyers, is that almost anyone can end up on that side of the table marked as a defendant. It's not that label that makes a person a good guy or a bad guy. It's not the label of prosecutor or district attorney or officer that makes someone a good guy or a bad guy. It's all about their character. It's all about their conduct. And I think this is a prime example of, we're not just looking at the position, we're looking at the person. And for us as defense attorneys, that's always hard to get people to understand when it's about our clients, who usually are not people of high position, especially back in my days as a public defender. These are just regular, everyday people who end up in a situation where they're accused of a crime. We want people to look at the person for what they are and what they've done or not done, and give them a fair shot. And I think that's a prime example of that here. We see a person who is in a position of authority, who people would have given great respect and deference to, who's now sitting in the defendant's chair and looking for a fair shot.
And I love talking to guys like you, okay, because it's clear you're the real deal, all right? And we have all of that here at the Law&Crime Network. That's why I love hosting this show. And I want to, that comment you made about how easy it is to be put in a defendant's chair. If you're a really good prosecutor, you know that. If you're a really good prosecutor, you make sure you protect against that and make sure that you are doing the right thing all the time. And it reminds me, we have something in common. When I got out for being an assistant prosecutor, when I was had a full head of hair and a flat belly back in the day, I went into private practice, and I took up pool cases for the public defender's office. In other words, cases that they had an overflow of. And it was a good way for me to start getting into the defense world and understanding that practice. I represented my first guy, and he was dead on paper. They had him locked and loaded, shooting a cop in a bar. And the guy was in jail for 4 years at the time I went in there to represent him. He was in a socioeconomically bad place. He grew up in a really rough area in the projects in New Jersey. And he was headed to trial. You know what, Andell? During an interview with the owner of that bar, we found out that there was a videotape turned over to the prosecution that was never produced in discovery. This is 4 years he was waiting in the county jail. We battled, believe it or not. The prosecutor wouldn't give us that tape. We eventually got it. And you know what? The prosecutor said there wasn't anything relevant on it. Not only wasn't there something relevant on it, it showed that my client wasn't the shooter. And the case was dismissed against him after all that time. And my father, here's the takeaway from that. When I went back to the office, I was working with my dad at the time, I remember him saying, hey, kid, you got that prosecutor thing out of you now? Because now you're a defense attorney, and when you start to make those judgments as a defense attorney about the guilt or innocent, someday an innocent client is going to be convicted of something they didn't do. It was a wow moment for me.
Absolutely. It's eye-opening. Look, all of us, we come up growing up, we watch cartoons, we watch movies. We're socialized to believe that these are the good guys, these are the bad guys. If they're wearing a uniform, they're a good guy, they're a hero. If they're in the back of the car and they're in cuffs, they're a bad guy. Mm-hmm. But as we get into the practice, and look, when I was in law school, I always knew that I wanted to try cases. But I was like, no, I don't want to do criminal defense. I don't want to represent guilty people. It's bad, la, la, la. Getting into the practice and actually becoming a public defender, I saw the reality of the criminal justice system, and that a lot of people are in there that did nothing wrong other than being poor or being in the wrong place at the wrong time. You learn not to judge people, but to go through the facts and go where the evidence takes you. And I think that's a great story and a great illustration of that, Bob, that case where you had a guy that sat in prison sat in jail for 4 years, but luckily he got a great attorney who got him a great result.
Yeah, and man, I could talk to you forever because I know you also do civil rights work. And actually, I got out, became a criminal defense attorney because I was so disturbed by what I was seeing happening with police and prosecutors. And I think the fans here of this show know that I am a cop supporter and a prosecutor supporter because I was one. But nevertheless, in some places, I saw some pretty disturbing conduct and actually wound up being a civil rights litigator, trying many civil rights violation cases for malicious prosecution, false arrest, excessive force, and federal and state court. My career actually, when I became appointed the head prosecutor, you can imagine the law enforcement community was a little concerned that a guy who was suing police departments and police agencies, but I explained to them, my job is to get you to do things correctly so that your careers are protected and we do the right thing. And sometimes doing the right thing is letting go of a case if you don't think you have enough evidence. Listen, Andell, again, on the other end, we're gonna go real quick. We're at a break right now with the jury for lunch in the North Carolina versus Wallace Bradsher case. District attorney on trial and representing himself. On cross-examination, we just heard some really interesting stuff with Craig Blitzer, who is another district attorney who turned state's evidence. It's a fascinating case, but I always like to go back to the opening statements, Andell, because that's where good lawyers put the case into context so that the evidence that's coming out during the course of the trial will make sense to the jury when they're hearing it. So let's take a look at a clip of the prosecutor's opening statement. And Andell, I want to get your thoughts on the other end of it. Welcome back to the Law&Crime Network. The old DA wife swap, since the caveman, it's been going on. But nevertheless, this is an incredible case of North Carolina versus Wallace Bradsher. He is a former district attorney. As you were listening to the opening statement of the current DA that's actually trying the case, he's on trial for obtaining funds, taxpayer funds, under false pretenses, aiding and abetting conspiracy, a couple of counts of obstruction, and we sprinkle in there a little misdemeanor for failure to discharge duties. I have Andell Brown with me, a former public defender and now private defense attorney. That prosecutor's opening statement, we just got right up to the pizza place, but it really sets out for our viewers what essentially is going on here with respect to this case. And there's this whole thing. Craig Blitzer becomes a district attorney. I guess Bradsher was kind of his mentor. Bradsher's wife, I know it's a little confusing. Bradsher's wife was working for him in Bradsher's office. Blitzer, in order to be able to financially afford it, is having a conversation with Bradsher, like what can he do, because he's going to be taking a lesser amount of money now that he's going from private practice into being a DA. And it's like, why don't you do what I do? Hire your wife. So on the first day he's sworn in, he's not only hiring, that is Blitzer, his wife, but he's actually looking for a pay increase. Okay. He submits paperwork. I think this is very relevant, Andell. We're going to get to you in a second about your thoughts about this. He submits paperwork, Blitzer, to the state that has his wife's name on it in the salary, and at the Administrative Office of the Courts, also known as the AOC, they flag it. And listen carefully. The prosecutor kind of gets a little wormy about this, but essentially what the prosecutor is saying is that the AOC said he recommends that he doesn't do it, but then they cite an ethics ruling, or the Ethics Act, that says you can't do it. But if I were Bradsher, I'd be making a big point here that no one really seems to have a definitive answer. He's doing it for years, open and notorious. Everybody knows his wife is working for him. She, in fact, is working for him. That was established. The AOC is saying we recommend you don't do it. The Ethics Committee is saying you can't do it. Well, an ethics violation isn't the equivalent of a crime. And just so the audience, if you go to the model jury charges, if you're ever so inclined to do something as crazy as that because you have nothing better to do, that's where the law is that's going to be read to the jury. And I always tell my trial people, Andell, or when I'm training, that should be the very first thing under the indictment is the jury charge, because that's what the jury is going to hear the law is. And essentially, on the main charge, it is makes a representation about a past or existing fact that is false, calculated and intended to deceive, and in fact then obtains property that they otherwise wouldn't be entitled to. So the prosecutor's opening, are there holes there, do you think, at least at this point in time?
I'm a defense attorney, Bob. I always see holes, okay? When I'm hearing the prosecutor's opening, and I think you just hit it when you read a portion of the jury instruction, false and intending to deceive or mislead. Everything that was done, for the most part, appears to be open and out, notorious. Everyone could see what was going on. For 4 years, it went on. The AOC knew about it. The chief judge knew about it. Everyone in the district knew about it. It wasn't a secret. So how is it intended to deceive if you've told everyone about it? If you're writing letters saying, hey, this is what I'm doing, is this okay? I think that is the biggest hole that I see in the prosecution's argument.
Yeah, I agree with you. Now, we're going to go to the rest of the prosecutor's opening statement in a minute, but right now we're at the spot, the place, the sweet spot of the case where now they know they can't do this, and they're going to meet in this pizzeria. I mean, it almost sounds like something out of a movie, right? And over pasta and whatever they're doing or eating there, they come up with this, concoct this plan. Now, I say concoct, but concoct may not necessarily be illegal. Okay, the state says we shouldn't do this, but I'll swap my wife with your wife. And let's look at some other facts you're going to hear, folks, from the district or from the opening statements here. In fact, Cindy is given, Cindy Blitzer, some work to do. We'll get to that in a minute, but apparently that ceases because she's a full-time nursing student. And Bradsher's wife is, in fact, working when this swap goes on. But anyway, the swap is not in and of itself illegal. It is maybe getting around the rules, but that's the point. They were told not to do it. They stopped doing it, and they found another way to do it that was not illegal. And then after Andell, we know this. After they did that, apparently they've now pushed a new rule out in the AOC that says before you hire anyone in the judicial/prosecutorial system from another agency, I think you got to get it approved somehow, or it's got to be vetted. But the point is that there weren't rules and regulations about this beforehand, and it's really fuzzy. What are your thoughts about that?
Well, Bob, it looks like what is happening here is stuff that lawyers do every day, is look at the rules and try to figure out how to get around them, how to get what you want without crossing that line. I think there's a lot of gray area here, and the prosecution is trying to make it black and white. As a defendant, as a defense lawyer, I think here you have to show that, look, we might have done something that wasn't smart, might not have been the best idea, I might have made a lot of mistakes, but it wasn't criminal. They tried to get around the rules, they tried to go close to the line, but I don't think that what he did crosses the line. I think that's the strongest argument that you have. I think that he tried in so many different ways to get out there and say, hey, this is what I'm doing. Is it okay? I don't think there's a crime.
You know, Andell, we go back to that piece about him representing himself, Bradsher. I think this is a huge mistake because in summation, and we always have to try our cases in summation, right? This is how I prepare a case. I know you do too. We think about what we want to say in summation, and then we back our case into gathering the evidence necessary in order to be able to credibly say that in summation. And what he is losing, Bradsher, by representing himself is the ability of a really good, passionate defense lawyer like yourself to be able to get up there and say, this guy, Bradsher, my guy, was just as confused as Blitzer is, because let's be honest here, so another point we haven't discussed. This guy Blitzer is an attorney. He apparently had a very good criminal defense practice. This is no neophyte in the legal community. He became the district attorney. He knows the difference between right and wrong and what the laws are and the laws, and he thought it was okay to do too, and now here he is testifying against my client Bradsher. Do you see, envision? Well, I guess Bradsher will try to do it, but wouldn't it be more effective if he had his own lawyer being able to say those words for him?
I totally agree, Bob. And I think one of the things that comes to mind is something that you mentioned earlier. It's about humility. It's about being humble enough to understand the gravity of the weight of doing a job such as a district attorney, and to take that very seriously and make sure that ethically and legally you're crossing your T's and dotting your I's. And it seems as if that may be the very thing that gets in his way, is that I would, and I'm sure you would too, if you were in a situation similar to this, get a lawyer to represent you. You know some of the best lawyers because you've been around the block. You know who's good, and I guarantee you there are excellent lawyers in that jurisdiction. I don't know why he's representing himself. I have the feeling that it's his inability to allow anyone else to handle things that's getting in his way, and that may have something to do with the lack of humility, which also may have something to do with why he's in this problem in the first place.
Wow, Andell, I love your commentary because I'll put it down into a nutshell, and it describes so many crimes. Pride comes before the fall, and that is so true, maybe potentially here, but certainly in a lot of cases. Folks, we have Andell Brown with us, former public defender, now private defense attorney. We're looking at North Carolina versus Wallace Bradsher. We're in a break. This is a case where a district attorney is now facing the music, if you will, sitting in the chair of the as a criminal defendant, representing himself on felony obtaining a property by false pretenses, aiding, abetting conspiracy, obstruction, and on we go. You are at the Law and Crime Network. It's a Dan Abrams production. It's the Live Trial Network, gavel-to-gavel coverage. We have great guests like Andell. Let's go back to the prosecutor's opening statement. I think we're at the spot of the pizzeria and onwards, Andell. And after we get done with talking pizza, we'll come back with you and talk about whether you think the prosecutor's opening was effective.
We can find the defendant guilty.
Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be with you for another hour. We are looking at the North Carolina versus Wallace Bradsher opening statement of the prosecutor prosecuting the former prosecutor, who's now a defendant, who is defending himself. You just have to love this, at least I do, have to love this case. It's got bizarreness written all over it. We have the great pleasure of having Andell Brown out of Miami, Florida, criminal defense attorney, former public defender. We've had some great discussions about this case. Andell, I hope you're still with us here. I want to ask you a couple questions. Something that is striking me is that this DA wife swap case where one wife is working for the other prosecutor in order to circumvent the rule that says that they're not allowed to hire their own wives, is not unlawful. The question here is whether they obtain property by false pretense. We went over a little bit of the law for our viewers in the previous clip with the prosecutor. I want to note one thing, and I think the same is true in Florida, and I looked up North Carolina. I know it's true there. The fraud has to occur at the time. There has to be an agreement to commit a fraud, or because he's charged with aiding and abetting. If they're just unable to do something afterwards that they had committed to do, that is not necessarily obtaining property by false pretense. Does that make sense to you, what I'm asking?
It makes absolutely sense. There has to be the mens rea present at the time for that offense and that charge to stick, Bob. And I don't know whether it's there because this story, it kind of is ever evolving. There was a time where it appears that what was being done was proper and in order, and then it seems like things change. And according to the prosecution, at some point is when this cover-up began. And as you know, Bob, and you always come with the dad wisdom, you might have said it's not the crime, but always the cover-up that gets you. And it looks like that's kind of where the prosecution is leading, is that in the beginning, they may have been doing the right thing, but at some point they realized that he couldn't do what he wanted to do, and it's a cover-up that ultimately gets him.
Yeah, we'll get to that cover-up in a minute. I just want to drill down, and I agree with you, on obtaining property. Again, they're going to be, the jury's read instructions. It's not just a wild free-for-all where they're allowed to find you guilty of being a bad guy, trying to get around the ethics rules. There's very specific law here, and this prosecutor's got to dance on the head of a pin, in my opinion, because the law's tricky. The law says that it has to be done at the time that you're committing this fraud. And like you just said, Andell, let's look at two important facts. When the wife swap happened, Cindy did go to Bradsher's office and worked on a case, which is apparently fulfilling that part of the agreement. Now, that may change, is changing down the road, but she does. And Bradsher's wife is working for Blitzer, and from all accounts was in fact doing the job she was supposed to be doing and getting paid for that. Now, my question becomes more of a rhetorical one. Why wasn't it, I know it's going to be hard to follow, a lot of people online are like, this is a tricky case, factually it is. But why is it that Bradsher wasn't saying to Blitzer, the two DAs, hey, why is my wife working and your wife's not working? That's not the deal. If this was a criminal, sinister deal, wouldn't Bradsher be calling up Blitzer on the phone, right, toot sweet Andell, and be saying, wait a minute, this isn't I'm letting your girl, go over there to nursing school and not have to work on a case, and yet you got my wife working really hard. Does that make any sense if this was criminal when it first started?
I don't see the dastardly plot. It seems like Bradsher ran a tight ship, yes, but one of the things he talked about in his opening statements was he had a culture of working hard. It wasn't a 9-to-5 culture, and he also had a family-first policy. So as long as you were available to do what you had to do, it wasn't like you clocked in and you clocked out. You just made sure you did what you were called to do when that time came. And another thing that kind of strikes me here, Bob, is that it looks like the wife of Blitzer is the one who obtained the benefit, yet Bradsher's on trial.
Yeah.
Bradsher was working, his wife was working. Blitzer's wife is the one who said, I'm going to nursing school and I'm still getting paid here. Because they didn't catch it, should they be the ones on trial? I don't see that as making sense. The person who gained the benefit here was really Blitzer's family and Blitzer's wife.
And Andell, great comments. And before we get to the cover-up again, we're going to go right now to the defense opening, but I would just make one comment to our viewers to be on the alert for, is what are the payment arrangements anyway? What kind of employment relationship was this? I know when I was prosecutor, my detective staff were contract employees with a set defined amount of hours, and if you went over that hour, there was overtime and blah, blah, blah. You had all sorts of things you had to deal with. But my lawyer staff were all at-will employees. There was no time period, whether you worked an hour or whether you worked 100 hours in a week, you got paid the same amount of salary. And prosecutors and employers in general are given a lot of discretion with respect to how they're using their employees. And I know a lot of people could be upset about that. Maybe somebody's not working. I mean, you heard this all the time in the office. I'm sure you did in the PD's office. This guy works harder. He's trying more cases. He's on weekends and holidays, and I'm getting paid the same amount of money for somebody who barely comes in, takes all their sick time, takes all their vacation time. The boss just loves it. But it doesn't make it a crime, in my opinion, unless there's something specifically that says you have to work X amount of hours. Do we see that here, or did we hear it in the openings?
I didn't particularly hear it, Bob, and I'm kind of waiting for that detail to be fleshed out as to what type of employment arrangement. Was this an hourly employment? Or kind of like you stated, either a salaried employee where you know, they might work 1 hour today, or, you know, they might work 10 hours this week. The next week they might work 100 hours, depending on what's needed of them. You don't want to punish someone for not necessarily having an assignment. If they are employed and they're fulfilling the general requirements of their employment, where's the crime? There's nothing illegal there.
Excellent point. Okay, folks, listen, it's great to have a guy like Andell on here. He's the real deal. He's like all the guests here on the show. We're going to go now to the defense. Don't be confused. This is the former district attorney defendant defending himself. So here you're going to have the opportunity to see a defendant district attorney giving his opening statement in his defense. I'm sure maybe this has happened before. I, in 30 years of a career, haven't seen it. Let's take a look.
Please.